My name is Jennifer Swinich, and I'm the Director of Practice Support at the Pennsylvania Medical Society. I'm reminded of working in a practice, and that 1 o'clock hour was when we started ramping up for the afternoon, so I understand how busy you are. I'm grateful to you that you chose time out of the busy afternoon to learn more about being more effective when appealing denials on both claims and prior authorization. If you recall, Tammy Tipton was our guest speaker out at our practice administrator meeting held here at PA Med in Harrisburg back in April. Tammy's the president of Appeal Solutions and has written and lectured extensively on medical receivables management. She's developed thousands of successful appeal letters used by physicians, hospitals, and other healthcare providers. I'm pleased that Tammy can join us today to answer your follow-up questions to the strategies she brought to us at our last meeting. At this point, I'm going to turn it over to Tammy to get us started. Welcome, Tammy.
Thank you so much for that introduction, Jennifer, and thank you all out there for joining us this afternoon for a little bit of follow-up to the content that we covered earlier. So we have some great questions to cover. We've got a lot of content here, so I'm just going to jump right in with the first question, which is the following. Do you get pushback from patients about assigning rights to appeal on their behalf as part of the check-in process? And it's great to anticipate this. You certainly want to be prepared for that scenario. However, I have to say, in the history of working with my clients, I've never had anybody indicate that this has been a problem. Most patients are quite happy to have you, the healthcare organization, advocate on their behalf through the appeal process. However, I would make sure that whoever is handling that process is prepared to reassure that patient who doesn't want to sign that authorization that you will be able to work with them to help them file that appeal. So if they indicate that they don't want to sign away their authorization to allow you to handle the appeal, then make sure that they are going to pursue an appeal of any type of denial, and make sure that they understand how to request any medical records or letter of medical necessity, and just reassure them that you'll be able to provide them support as they work through that process on their own. Great question. The next question we have is, how long after faxing an external appeal request does it normally take to hear back from the company? And this does vary according to what type of external process that you're following. So, of course, Medicare, Medicaid would have a separate answer for that. However, I put in here the answer that would apply to any external review organization that's accredited through the URAC process. The Utilization Review Accreditation Commission actually accredits many of these organizations. And so they stipulate that if it's an expedited request for review, it be processed within 24 to 72 hours. However, standard reviews can take a medium duration of 5 days or up to 20 business days. However, note the item C in this answer, and that's that the time frame starts upon receipt of all the information that has been forwarded to the organization, including any additional information that that review organization may deem to be critical for the review process. So what happens here is that external review organizations may get a request for review from a patient, and in that scenario, then they have to go to whatever providers might have critical information and medical records, and sometimes gather that information. They also have to gather information from the insurance carrier. If the patient makes the request through the insurance carrier, then the insurance carrier may have all that information already organized, and then they will submit it all, but those variables can vary. So it kind of depends really on what their start time for the review process is and when they get all that information. So just as a point of clarification on this, if you have a review organization that seems to be taking way too long to make the reviews, I would have some type of follow-up process with them so that you're asking them if they have started the review, if they're still in the information gathering phase, and just what's going on so that you can get a feel for what is causing those delays. Our next question is, when do you start the appeal process? Many insurance payers want you to go through multiple steps before appealing. And so when I was reviewing this question, I was very curious to know what kind of barriers the insurance carriers were throwing up to your request for appeals, because I haven't heard a lot of different types of things in regards to barriers to the appeal process. But, you know, I do think it might definitely depend on the payer type and the type of review. So I brought up some examples that I could think of. This may not be applicable to the barriers that you're facing. And if that's the case, then be sure and chime in later at the end and let me know what specific types of things the payers are saying that's putting off the appeal process. But first of all is the critical bureaucratic paperwork process that the payers so are enamored of. And in particular, Medicaid and workers' comp have a lot of prerequisite paperwork. And so often trying to fight that paper trail is almost impossible. It's, you know, it's much more critical to try to provide them with those items that they're requiring if they need a certain form filled out or a certain authorization. The next thing would be medical records requests. And I really encourage everybody to definitely be prompt with those medical records, but do not get into the habit of sending multiple submissions. So if you have a payer that keeps asking for the same medical record, then in that scenario, I would cite HIPAA and the fact that they are bound, just as you are bound, to have a very protective process for protecting those medical records, that if they're losing records and having to issue repeated requests for the same record, then that could very well be a HIPAA violation because it would appear that they're losing records on their end. So always try to keep them honest in regards to medical records and only requesting what they need and one request. The final scenario that I could think of would be that it is, again, what are the steps that typically apply to provider appeals, and is it something specific to the provider appeal process that they're demanding from you? So if that's the case, then you may be able to get around those requirements just by making it clear to them that you are trying to pursue the patient appeal process because you have a patient authorization to represent them in the appeal. And then that would negate the need for any kind of additional steps that would apply to provider appeals. So try those in regards to accessing the appeal process without any more delays. Our next question would be that some of you are very interested, of course, in preventing the denials in the first place. And we did talk about that in the course of the workshop, being proactive rather than reactive. And so again, just to emphasize, we went over a lot of revenue cycles and really tried to focus on the fact that this training should be about patient advocacy. So I've kind of summed up that approach to training with the following staff areas. And so in regards to preventing denials and patient access, train them to be access experts so that they do all of those pre-treatment benefits assessments that allow you to really put through clean claims without a hitch. Utilization review also really supports the patient access area. Your UR department needs to have payer-specific strategies for prompt approvals and even helping your clinical staff do more peer-to-peers so that denial issues are taken care of pre-treatment. The billing area is a major area where staff training can really empower everybody. You need to designate time for payer-specific research and resource development so that all of your efforts can really be payer-specific and that you know exactly what they're expecting in regards to your claims. Also providing resources regarding legal protections. We covered a lot of legal protections in the workshop, and I hope that that can be an area where you support your billing staff with even more training in that area. The CDI department or your documentation improvement people, these challenges are very site-specific. So you need to really understand where your documentation shortfalls are and what your management team can do to support change in improving that documentation. And then finally, the negotiation team, they need to be aware of any problems all along the way. So all of these areas need to be reporting to the negotiators so that they know what to focus on in negotiation in regards to getting the payers to be a better partner in the whole process. So those are some, again, of the preventing denial ideas in regards to staff training that I hope you're able to implement. Our next question is, what is the #1 reason a claim is denied? We find that most clearinghouses are our best source of information in regards to claim denial volume, and missing information typically accounts for more than half of initial medical billing denials. So 61%, that's quite high, and the source of that is beckershospitalreview.com. This is also, of course, a huge source of write-offs too. So it's very important to make sure you have a clean upfront process for obtaining all the information. One of the suggestions I might make in this area in regards to improving your data collection is, does your organization need a data quality manager? And some of the things that a data quality manager might be in charge of would be to research missing information denials for the root cause. So is there something kind of systemic in your process that causes you to miss a specific piece of information on an ongoing basis? And this can sometimes be really closely tied to your technology and what kind of prompts and what kind of alerts your technology might have. Also, this type of personnel position would be able to identify problematic data collection scenarios and design training sessions around improving data quality. And then finally, they would probably be in charge of assessment of new technology solutions, because there's so many options out there on the market for improving data collection, making sure you're getting all that, capturing all that information. And so hopefully you can find the right tool for your practice to be able to improve performance in that area. Great question. Our next question is, can you get a pre-authorization for out-of-network coverage? And this is a great question because it really shows that those of you that are handling out-of-network scenarios are being very proactive and thinking of what you can do for that patient to make sure that their insurance coverage does kick in for that out-of-network treatment. So the problem is that if you're going about some type of pre-authorization for out-of-network coverage, you're relying on phone or online eligibility verification. And a lot of times there's just a lot of shortcomings to that. As we all know, the carriers, first of all, read you a long disclaimer before they give you any information at all. So I really recommend that, in particular for out-of-network care, because you have no information, no idea except for what the patient is providing you in regards to what the coverage would be, that if it's going to be a high dollar claim, you might consider pursuing written verification of that coverage. A written request for coverage information would need to cite your assignment of benefits to make it clear that you have the right to obtain that information. They're not going to just respond to a written request for information without some type of authorization from the patient. Now, of course, a lot of legal protections would apply to that. So you need to understand your protections on a state-by-state basis for obtaining that information, and sometimes you may have to cite ERISA. But also the patient, of course, can assist with that process too, and kind of put some pressure to bear on the payer to provide information in regards to that. But that's a great question, and I would really look at your patient access training to see if you need to provide more training regarding what legal requirements to cite in that scenario and what payers you're most frequently seeing in regards to problematic out-of-network coverage issues. And that way you can really tailor it to that payer and to what your protections are in getting information. Okay, our next question is, what if the denial was regarding a pre-authorization for a surgical procedure and it was started with a different procedure code or CPT? And the answer to that, short answer, is appeal that type of denial. Because the pre-authorization process is not meant to be so specific that it always only applies to one specific CPT. In fact, there are a lot of protections that even state that, particularly through the URAC certification process, that providers shouldn't always be required to submit the codes prior to the treatment in order to confirm the coverage. So I would strongly recommend that you appeal that. Some suggested wording for that type of appeal would be, as indicated on this slide, that as a treating physician makes treatment decisions that are available with the clinical information that is available at the time. So this is explaining that once the treatment or procedure was initiated, clinical decisions are ongoing, constantly reassessed, and the plan procedure often changes. So this makes it a point that you submitted what you had at the time, it changed slightly during the procedure, and that should be considered by the payer. So I hope that you would be able to get that type of denial quickly overturned if you're using, you know, a similar CPT code to the one that was initially pre-authorized. Our next question is, what are the recognized productivity matrix for clinical denial appeals? And this was particularly submitted in regards to medical necessity denial appeals, as well as DRG reassignment denial appeals. So in order to answer that, I got some statistics from a publication called workingnurse.com that actually looks at the utilization review process very carefully. And so they provided information regarding denial rate reduction, outcomes, quality standards, and caseload. So that site is directly on your slide. But basically what this study found was that your value-based and quality standards impact utilization review performance measures because, first of all, it's very challenging to measure these. You've got to have effective measurement of the care transitions and utilization variation. Also, it's important to look at these matrix from a standpoint of reducing preventable admissions, readmissions, ED visits, complications. A lot of that's kind of definitely more applicable to the hospital side, but it kind of gives you an idea of some of the challenges to coming up with matrix for your utilization review department or your staff. The important thing here was to engage patients in regards to these different variables to make sure that you are obtaining all the information and really representing the care correctly when you're trying to go to the payers for authorizations of these different types of treatments. And that study is available at Becker's Hospital Review, and I encourage you to take a look at that because it's very, very detailed in regards to some of the metrics you can look at in utilization review. Our next question would be, is there a website that gives all insurance companies remark codes? That is definitely out there on the website, and the slide cites the Washington Publishing Company website that has all of the codes and what those codes stand for. You need to, in order to really get a good handle on your denials, you need to understand the remittance advice remark codes, or the RARC codes, and the CARC codes, which are the claim adjustment reason codes. These two types of codes really support each other and provide you more extensive details in regards to what the denial is. So I'm very grateful that you're wanting to look at these descriptions of the codes, because a lot of times you'll get very comfortable with maybe your top 5 or 10 denial codes, but you'll get occasional codes from your payers that don't really make any sense, don't really explain the denial. And in that scenario, you really may need to go to this website and actually look at what the terminology is for those codes, and to look at both codes in conjunction with each other to get a better handle on why it was denied. So that is your resource for that, the Washington Publishing Company. Our next question is, what to do when we submit a corrected claim with the letter and it gets denied as a duplicate? And this, again, short answer is appeal. So it's very important because as we talked about in regards to your volume of denial, this is actually the second highest reason that claims are denied, is duplicate denials. So some suggested wording for how to approach a duplicate denial. I've got some bullet points there that give you an idea about how to appeal that scenario. And one way is to request an audit of benefits applied to that date of service, just to make sure that they actually have processed a claim for that treatment. So if you're getting a duplicate denial that you can't substantiate on their end, ask them for an audit of that and a clarification regarding the date the original claim was paid, the amount of payment, and to whom benefits were released. This should be able to really allow you to nail down whether they've paid it or not. The other option there would be to state that if the claim remains denied, you want a response from a certified claim auditor familiar with the bill procedure, because maybe the bill procedure does have a lot of different components of it that are billed separately, and this would allow you to get an answer from a specific person instead of having them send it through the electronic claims processor that's not actually looking at the claims detail. So just keep a lot of pressure on them to provide you more specific information so that you can reconcile the claim on your end. Because this kind of sounds like a situation where what they're telling you is not matching up to what you have on your system. And our next question is, the insurance information was added after the discharge due to coverage, discovery, COBRA approval, coordination of benefits. There's a lot of reasons that a lot of times we get new information regarding the insurance. So what is the best practice or process? Should you attempt retro authorization, or should you just file it, get your denial, and appeal? So in that scenario, I really recommend that you do attempt the retro authorization process, citing the approval date. Typically, when you've got a recent approval, that allows you to kind of start the process over again and get your retroactive authorization. So provide them with documentation related to the late authorization or a denial from another carrier, and then ask them for a retroactive authorization. It's kind of important to go that route because that gives you the option of getting a denial on the authorization process, and then even going ahead with the claim process and filing appeals on the back end too. But the retro authorization process sometimes gets routed differently with the carrier and goes more to the clinical staff instead of that provider appeals process that we want to avoid. So retro authorization really is your way to go there. I did include some suggested wording for that there. So that's kind of lengthy. I'm not going to read it all, but just take a look at that wording and see if that type of suggested wording would apply to your scenario. Our next question would be, if Medicare downcodes an E&M visit, they claim they do not have to provide us with their audit sheet. Do you know if this is correct or not? We don't agree and feel we are entitled to them to show us how they came up with the level of service they have changed. And that's a great, I'm so pleased that you want to see that level of detail from your payers, particularly from, you know, your Medicare carriers, because it is important and it is the only way that you're ever going to truly nail down how they're calculating E&M. So the answer I have provided there is that CMS gives you of course, the criteria and the 95 and 97 documentation guidelines. However, that's often supported at the payer website with an audit tool. So be sure and take a look at that audit tool. However, understand that medical decision-making is the common source of coder-to-coder variation. So they've done a lot of studies. They've done a lot of studies on this, and if you hand the same medical records to a lot of professional, well-credentialed coders, they still often get a variation in their medical decision-making measurement on those. So a coding expert familiar with this problem of coder variation recommended that the Marshfield Clinic tool is a good tool for selecting evaluation and management coding consistent with Medicare requirements. So take a look. You can Google that on the internet and access that tool. Take a look at that and see if that assists you in giving your coders more guidance in regards to selecting the E&M visit. But I do want to encourage you to continue to put pressure on your carriers to release those audit sheets, because that is valuable information. It doesn't, technically, I don't know of anything we can cite to demand that. If they say no, they don't have to release it. But I think as you elevate your appeals through higher levels of appeals with Medicare, that audit sheet will definitely get looked at again. And so it's critical to make them aware that you know there's an audit sheet out there and that it better support their decision on that. And our next question is, when the payer uses different criteria per their policy and it conflicts with hospital criteria. So an example would be coding of emergency visits. The payer uses a different level of care criteria and the hospital uses E&M coding based on interventions done. Payer uses 5 levels based on final diagnosis. So this is getting into the fact that payers do not necessarily only look at final diagnosis. A lot of times they look at the presenting problem, particularly where there are risk factors, differential diagnosis being considered and other contributing factors. And a lot of times this really goes back to the quality of your documentation. If there's kind of borderline admissions, then you need to have all those risk factors and differential diagnosis well documented in your documentation, and being able to submit those with your appeals can really get those overturned. So providers need to correlate the presenting problem, the risk factors, and the final diagnosis to the interventions and diagnostic studies performed. So that is directly a quote from the American Emergency Physician website. And so they have a lot of good information at that website, which I've cited at the bottom of that slide, for how to really support those type of scenarios where you have an emergency room treatment, but you don't think you've got really, maybe you're not capturing good enough documentation to support the final diagnosis. So take a look at that and see if that can help you in getting and training your clinicians to provide the exact information that's going to be required to meet those payer requirements on emergency care. Very technical issue. Our next question is, what are some ideas or strategies for handling claims shufflings to the independent processing or TPA third-party types of administrators that utilize random denials or even state that they didn't receive the claim when the payers send them? And then, of course, this question also points out that a lot of that claims support is with offshore representatives, and there's a whole new sort of set of challenges when dealing with offshore reps. So first of all, just to confirm that that's a terrible way to handle business, I just want to say that to have requests ignored is not only frustrating, but it really it delays the entire access to the appeals process. So it's really important that while that's a hugely frustrating scenario, that you really do make those carriers aware that that's an unacceptable business process, and that if they're going to work with these outside organizations, they have to meet standards for processing those requests and those claims in a timely manner. So continue to demand compliance with prompt payment requirements and ask for justification for any payment delays. Often you may have to do this in writing, so have your appeal letter templates ready for handling these type of delays. You can target payers with poor compliance and, try to cite in these letters multiple instances of delays so that that carrier gets an understanding that that third party that they're outsourcing to it's not just a one-time thing that you're dealing with, it's a pattern of behavior on their part. Also, demand written claim acknowledgments from your payers so that you have some type of acknowledgement of when they got the claim and where it went from that point. And then finally, one suggestion would be to get the patient involved. This is when the claim is in limbo and you're not quite ready for an appeal often, but the patient, knowing that their claim is still uncertain, they should really want to get involved with this type of scenario too. So hopefully you'll be able to get the patient maybe to call and put additional pressure on that payer to get things expedited. And our next question is, does ERISA help with out-of-network care as well as in-network scenarios? And the answer to that is yes. ERISA beneficiaries should have access to the studies, the schedules, and the documents that contain information and data in regards to how they're processing benefits, including out-of-network care benefits. So you can make a disclosure request if you are a qualified party. And I hope I covered this really well during our workshop. This is such an important component of out-of-network appeals. You have to attach that authorization to represent the patient in order to get at how the carrier is calculating that out-of-network benefit. So use the Department of Labor website in regards to these type of requests. And there's a great document on this slide that specifically was writing to a carrier and to a self-funded plan to let them know that that type of information does fall under disclosure on a UCR or usual customary and reasonable denial. There's a great quote that for out-of-network providers, it would seem clear that usual and customary rates paid to behavioral providers need to be comparable to those paid to substantially all medical and surgical providers. So that is from the following source, which was a really great document on how behavioral care is one of the areas that's really targeted for poor UCR calculation scenarios. And actually, there's a lot of data out there that indicate that ERISA does provide a lot of protections for UCR calculations on behavioral care. So if you're providing mental health care treatment, be sure and take a look at that specific document in regards to calculation of out-of-network benefits. Also, cite support for your pricing. And sometimes if you're a large organization, you may actually be purchasing a third-party product to help you establish your pricing. Be sure and cite that information if it supports that the carrier is really far away from your pricing. And also, one other source of pricing out there on the internet would be fairhealth.org. And you can go to that website, enter in a procedure or a CPT code, and take a look about what information or data they have regarding what a typical or an average payment would be for that specific procedure. And that can be helpful to cite as well. Our next question is, are more insurance companies moving to only allowing one level of appeal per claim, and what can be done about this? And I think this is a very unfortunate scenario that payer guidance is really confusing related to this, because a lot of times their website does clearly say things like, according to our policy, we only allow one level of appeal for practitioners or providers. And that is, that may be true if you are pursuing only that provider appeal process. But keep in mind that if you are authorized to act on the patient's behalf through a patient authorization form, then you have access to all higher levels of appeals. That's actually the same type of form that an attorney would use to pursue litigation on a patient's behalf, is an authorization to appeal. I mean, they might have more extensive paperwork, but a lot of the lawsuits that are filed on behalf of the healthcare organization pursuing a carrier, they have to have those authorizations in place in order to pursue through the legal process, unless they're litigating contract terms. So be sure and rely on those patient authorizations. The authorization, depending on the specific wording, gives you access to all external appeal process and even the ability to litigate on behalf of the patient if you were to have to go to that length. So technically, it can be true that you only have one level of appeal if you're a provider, but you can get authorization from the patient to pursue higher levels of appeal. And that's where you get a quality review process. So you almost have to do that with some problematic payers who do not provide a high quality process to providers. Our next question is, one or two of the practices I bill for are very large practices and we see payer trends in denials. Do payers have to offer an option to address multiple patient claims in a single appeal? Would you ever recommend doing this? It's costly and time consuming to send 10 separate appeals on the same issue. And yes, you are certainly, it's an efficiency, and you're certainly encouraged to include multiple appeals if they're all the exact same scenario on one appeal. There's actually CMS guidance on their website that encourages you to consolidate similar appeals into one appeal. And so I gave you that citation in case you're having trouble getting your CMS or your Medicare carriers to allow you to submit on one appeal multiple scenarios. But I do encourage you to do that from an efficiency standpoint. And also from a standpoint, if let's say you write just a great appeal, you've covered all the bases, and they overturn it, that's a scenario where you need it overturned for all patients that have had claims related to that scenario. So getting it all up front on one appeal letter will assure you that if it's overturned, that they include all of those claims in their overturn. So I do recommend that you do that. Our next question is, how to get a positive response from your first appeal. It seems like even though we present the facts clearly, it takes several appeals to get a positive outcome. And you just gotta acknowledge that there is no disincentive for payers to have a poor appeal process. So to me, there are three areas where a disincentive might emerge. And that's that in regards to your technology. it doesn't make any sense for carriers to force providers into additional levels of review if those reviews are costly to conduct. So they really rely on you to drop it after one appeal. So if you have some sort of technology that really helps you track and submit through all levels of appeal, I think that's one strategy for overcoming this scenario where they really have maybe a poor appeal process and they don't really care to improve it. Another area is consumer activism, getting your patients involved and letting employer groups know about these problems can be important in regards to improving the appeal process. And then finally, legal remedies. Poor claim and appeal review is too expensive to litigate. So as legal resources grow, you need to consider if you have specific scenarios where legal options might be applicable, then pursuing that would be one disincentive for the payer to have a poor appeal process, because that's where they hope to overturn anything that might really be a liability to them in litigation. So it's an unfortunate answer, but I really think that keeping pressure on them, pursuing through all levels of appeal is one key to making it less attractive to have a poor appeal process. Our next question is there a deadline on insurance takebacks? Unfortunately, Medicare really has no deadline for overpayment recovery. And I've got a site there that really kind of cites that information from the overpayment brochure that they circulate. So, however, your commercial carriers do allow only a 2-year look back period, but as the Novartis Solutions website warns, do not assume a standard look back period, because they actually can look back further, and they actually have a lot of exceptions to the specific protections related to overpayment that are coming into play more and more often. So keep in mind that Pennsylvania law states that 24 months is their deadline for asking for takebacks, but they increasingly use these exceptions to go even farther back. And that would be if they suspect fraud, waste, or abuse. They can go back further if they're going to claim that it was a fraudulent type of scenario. Duplicate claims, where they can make a clear case that they've paid twice, would be another exception. And the denial was required by a federal or state government plan. They have additional protections that apply to those types of plans because it's the taxpayer money and they have a higher fiduciary role in that. And then, of course, services subject to COB, because COB takes so long sometimes to parse out and get to the bottom of. Sometimes they are allowed to go back farther on a COB issue. So unfortunately, there's a lot of things they're throwing up as allowing them a longer scenario. So you've really got to take that into consideration when you receive these and figure out how you're going to fight it going forward. And then our next question is, can you summarize the 3 steps to get started improving appeals? And this is what we're going to wrap up the slides with, because I really want to encourage you that if you have all this information and you find it a little daunting, to really think about narrowing your focus in using the information. And one way to do that would be to pick a high frequency denial that's impacting your AR, or a denial that's particularly problematic for your clinical staff, something that just really gets at them because it's so obvious that that should be covered. Once you've identified a particular denial scenario, be sure and follow step 2, which is to appeal using the patient's authorization to appeal, because that gives you broader rights to demand things like the internal documents that support their denial. So use the patient's authorization and include a demand for the documentation that supports their denial, because you want to see if they're actually going to give that to you and what that actually says. And then my third recommendation would be always appeal to the highest available level. Even if it's going to require you really just to submit the same information that you submitted it goes through a more rigorous review. Also, if you can cite information that you've obtained during these lower levels of appeals, maybe you found out that they don't really have good clinical information, or that they didn't really assign a specialty reviewer to look at pediatric care, then you want to raise those issues to the independent review process. So that would be my 3 steps for really getting involved if you feel like you don't know where to start in regards to improving your appeals. Okay, so that wraps up our slides. And I want to thank you for taking the time to listen to this information. We've got a little bit of time left now for some additional questions related to that content. And I believe we also have a poll that we'd like to conduct at this time. So I'm going to turn it to Jennifer to see what we have at this point.
Okay, thanks, Tammy. So we did have a few questions come in, and we are going through those now. And while we're collecting those, I do want to launch our poll. The poll is related to the patient authorization form. We were curious if anybody is using a patient authorization form, if they've implemented that with the practice. So if you want to take a moment and go ahead and answer our question there. Have you begun to use the patient authorization form to allow you to advocate on your patient's behalf? We've got yes or no, or not yet, but we plan to. And while you are filling out your poll question, I'm going to go to one of the questions that came in. If we had an example of the assignment to act on the patient's behalf, and we do have a sample of that, we'll make sure that all of the attendees today get a copy of that. And we still have questions coming in. So Tammy, would you like me to move on to some of the other comments that came in?
Yes, that's great that you can circulate them a sample document on the assignment. And what do we have for the next question?
So this is more just a commentary about when to start the appeal process. Some payers require you to do a claim reconsideration before you do an appeal. Other payers require you to file a claim investigation on Navinet and have that reviewed before you do an appeal. So can you address that, and maybe how the process might be different whether you are using the patient authorization or not? Mm-hmm.
Yeah, well, those are, as we've indicated, those appear to be particular barriers that they're putting up just for provider appeals. So my advice would be that certainly go that route, and if it's effective, continue to use that route. But if you know that you always go the route of the reconsideration first or the Navinet form, and you know that that's just kind of almost always upheld by the provider, that's a scenario where I would really consider just doing away. I mean, you don't have to file any provider appeal. You can go straight to the patient appeal process with that patient authorization, and then they should not be able to require any kind of prerequisites to that appeal. You should be able to have direct access to the patient appeal process.
Thanks, Tammy. We had another comment come in where there is the practice composed a patient authorization form, but the payer would not accept it. It took forever to find out where to obtain their form. The payer made it very difficult to obtain it and held the appeal in suspension until they were able to track it down. Can a payer require that you use their form?
Yes, unfortunately, particularly with ERISA plans, ERISA has specified that they can have their own internal form. So hopefully this is a payer that, that now that you know that, you can use their form when dealing with that payer. That's a really unfortunate scenario, and a lot of times, if you look at and compare both forms, you're submitting the same type of information. So it's hard to understand why you would be required to submit theirs when it has basically the same information on it. But as far as I know, there's not a way to get around that, payers using their own specific forms. They do have to be easily available, and sometimes patients might be, might have some knowledge in regards to that. They can certainly be the ones to check into that if you think you're going to need an authorization form from them. But yes, I do believe that they have the right to use their own internal forms. Do we have another question?
Oh, I'm sorry, I've been talking away and it was muted. Technical difficulties on my end. I apologize for that. I have the results of the poll question on how many of our listeners are using a patient authorization form. 27% are using a form. 45% are not using a form, and 27% are not using a form yet, but they plan to start.
Excellent. That's very interesting. We'd love to know from those who are using the form what their experience has been. Obviously, we have from the last question, we have that that it can be problematic for carriers who have their own form. And the reason behind that, I might add, is that, again, this is the patient appeal process that they're signing away, and the patient really wouldn't have multiple insurance carriers. So it would seem more, if the patient were pursuing their appeal process, they would be using all the forms with that payer. So that's kind of where that stems from, is that this is a patient action, and they're signing their rights away. So it is kind of payer specific.
Okay, thanks. And now knowing that that is how that payer is going to treat that, we'll do some digging on behalf of our members here to see if we can't keep those forms handy, for practices as they need it.
Excellent.
Okay. Are there any other questions or comments? Another comment, we had a patient complain about signing over the right for us to appeal on their behalf. I believe that was one of the questions that you addressed, Tammy, earlier on in the presentation.
Yes, and you have to, there's probably expertise. I would say most people that want to retain that ability to handle their own appeal might have some expertise. Maybe they have a legal background, maybe they have a clinical background, but they feel comfortable advocating on their behalf. So I really, a lot of times, consider that a positive, because if the patient can write an extremely persuasive appeal and that gets denied, I mean, they will be often very motivated to continue through all the higher levels of appeal, and even perhaps to litigation. So I don't really consider that a negative. Now, I don't know what the specific scenario or how that outcome happened with the person who raises this issue, but I hope that in that scenario, the typical end result is that they are able to get that overturned.
Okay, thank you. All right, well, I don't see any other questions coming out. If you have any other questions, you can always feel free to email us here at PAMed. And Tammy was kind enough to put her contact information on the final slide there. Otherwise, this concludes our presentation today. Thanks so much for joining us. A recording of today's session will be made available for playback on our website. Watch for PAMed's weekly email newsletter for more information on that once we have that available. I want to thank Tammy Tipton for her time and expertise today and for sharing that with you. We really appreciate it on behalf of our practice administrator members. This is a huge pain point, I know. Otherwise, have a great rest of your day. Thank you so much.